Yo, 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 it's your boy, the insurance junkie, your fiduciary fella, the all-star advisor Alonzo Hall, and I've returned today with another ADH Wealth solution. Today, we'll begin to discuss fulfilling all of your financial needs. To contribute to channel growth, the links are in the description. To schedule an appointment of your own, or to purchase life insurance directly up to $1 million with no medical exam and an instant decision, my information is in the description. Lastly, make sure you hit that like, drop a comment, subscribe, and hit that notification bell so you're made aware every time I release new content. And as always, share, share, share. And now, here's our next feature. Salute, 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 salute. It's your boy, the insurance junkie, your fiduciary fella, the all-star advisor, Alonzo Hall. And I've returned today to weapon tap on your head with another ADH Wealth solution. Today, we're going to be looking at a section of the Uniform Investment Advisor Law Exam License Exam Manual, or the Series 65 Exam Manual. As you know, your fiduciary fella, the all-star advisor, is a fiduciary fella. And what we're going to do is we're going to look at Unit 7. Let's see here. So Unit 7 talks about ethical practices and fiduciary obligations. We're going to look at this section, which is the fiduciary responsibility of investment advisors. Before we go in, ladies and gentlemen, make sure you hit that like, drop a comment, subscribe, and hit that notification bell so you're made aware every time I release new content. And as always, share, share, share. Lastly, to contribute to channel growth, to purchase life insurance directly up to $1 million with an instant decision and no medical exam, or to schedule a one-on-one appointment with a licensed financial professional, the links are in the description. So as we proceed to give you what you need. So here it says, again, this is Unit 7, and Unit 7 for fiduciary responsibility of investment advisors. So the Unit 7 Learning Objective 1 is to identify the important ethical considerations and fiduciary responsibilities in providing investment advisory services. Unlike broker-dealers and their agents, investment advisors and their IARs have a fiduciary responsibility to their customers. That obligates these advisors and their representatives to put their clients' interests ahead of their own. That is the primary reason why advisors need their clients' consent when acting as agents or principals in trades with them, as covered in the previous unit. As fiduciaries, investment advisors must identify and address all material conflicts of interest by eliminating or disclosing such conflicts. For example, that advisor may have to tell you, hey, listen, I do get paid a commission from the company, but I also charge a fee for, our services, because oftentimes when we sit with clients, they can't afford a product or they decide against it. And that's a lot of time we put in for sometimes no money. Clients rely on the advice of their advisors and must feel confident that those advisors are working in the client's best interest. If the advisor also engages in non-securities related activities, such as selling auto insurance or real estate, these represent potential conflicts of interest, time taking away from watching the market, and must be disclosed. Now there's an example test question here, and it says investment advisors and their representatives have the obligation to place their clients' needs ahead of their own. This is legally known as A, avoiding conflicts of interest, B, making full disclosure, C, fiduciary responsibility, or D, playing fair. And the answer is C, fiduciary responsibility. The obligation of an investment advisor, an IRA, is to place clients' interests ahead of their own, and this is known as acting in a fiduciary capacity. Another responsibility is recognizing your capabilities. It is an unethical business practice to promise to provide services that you know can't be provided. And one other relevant idea is criticizing the work of other professionals. This is not to say that you can't point out suggestions you would have made differently, such as a different clause in a will, etc. But unless you are an attorney or an accountant, be careful about criticizing legal or accounting work performed by those professionals. Now we're going to go into the hedge clauses. So a constant concern of the regulators in any attempt by an investment advisor to waive the implied fiduciary responsibilities inherent in the client/advisor relationship. One of the most common methods of doing so is through the use of the hedge clause, sometimes referred to as an exculpatory clause. This test is consistent with the Investment Advisors Act of 1940, which states that any condition, stipulation, or provision binding any person to waive compliance with any provision of this act or with any rule, regulation, or order thereunder shall be void. In a recent example, one state took issue with a contract that stated, "It is understood that we will extend our best efforts in the supervision of the portfolio, but we assume no responsibility for action taken or omitted in good faith if negligence, willful or reckless misconduct, or violation of applicable law is not involved." So, here's the bottom line for the exam. You will be presented with a question or two containing a statement to the effect of, "The client agrees to waive rule violations by the IA or other securities professional." The answer to choose is the one that states, "Waivers are never permitted." This is not to say that the acts prohibit the use of all hedge clauses. For example, the SEC has not objected to clauses that limit the investment advisor's liability for losses caused by conditions and events beyond its control, such as war, strikes, natural disasters, new government restrictions, market fluctuations, communications disruptions, and so forth. Such provisions are acceptable because they do not attempt to limit or misstate the advisor's fiduciary obligations to its clients. But it's highly unlikely that one of these choices will be on your test. Let's take another look at example questions. 1. An investment advisor runs an advertisement in the business section of the local newspaper. The ad describes the nature of the firm's model portfolio and indicates that it has outperformed the overall market by 800% over the past 10 years, and therefore they guarantee that their clients will more than keep pace with inflation. At the bottom of the ad, in smaller print, is the following statement: "Results are not guaranteed. Past performance is not indicative of future results. These results are not normal and cannot be expected to be repeated." This is an example of what? A. Properly worded disclaimer. B. An improper hedge clause. C. A violation of an investment advisor's fiduciary responsibility. Or D. A wrap fee account. And the answer is B. Hedge clauses may not be used to disclaim statements that are inherently misleading. No ad can state a guarantee like that. Question 2. Which of the following statements regarding the use of a hedge clause by an investment advisor is correct? A. The advisor's brochure must always contain at least one hedge clause. B. A properly worded hedge clause may be used to minimize the investment advisor's fiduciary responsibility. C. A hedge clause that limits the investment advisor's liability for losses caused by conditions and events beyond its control, such as war, strikes, and natural disasters, would generally be acceptable to the administrator. Or D. A hedge clause that limits liability to acts done in bad faith or pursuant to willful misconduct, but also explicitly provides that rights under the state or federal law cannot be relinquished, would generally be acceptable to the administrator. And the answer is C. The regulators have not objected to the clauses that limit the investment advisor's liability for losses caused by conditions and events beyond its control, such as war, strikes, natural disasters, new government restrictions, market fluctuations, communication disruptions, and so forth. Such provisions are acceptable because they do not attempt to limit or misstate the advisor's fiduciary obligations to its clients. Limiting liability to acts done in bad faith might cause the unsophisticated client to fail to understand that he still has a right to take action, even when the acts are committed in good faith. Fiduciary responsibility cannot be limited by hedge clauses. And now let's take a look at one of the other huge things about being a fiduciary, which is disclosure of compensation. One of the areas where the importance of the fiduciary relationship comes into play deals with compensation. As we covered when discussing advisory contracts, compensation details must always be disclosed. This would include the method of computing compensation, refunding of prepaid fees, the type of compensation, hourly fees, fees based on AUM, commissions, etc., and any incentives or other compensation from the issuer of the securities recommended. That last bullet point is particularly important because of the fiduciary relationship. Incentives or bonuses will undoubtedly present a potential conflict of interest, and the IA must always put the interest of the client first. We learned in the previous unit that performance-based compensation is prohibited under all circumstances unless there's a qualifying exemption. Now, we'll look at those exceptions. Under state and federal law, the exceptions from the performance fee prohibition apply to contracts with a qualified client, defined as a natural person or company that immediately after entering into the contract has at least $1 million under the management of the investment advisor, or a natural person or company that the IA has reason to believe that immediately prior to entering into the contract has a net worth exclusive of the primary residence, in the case of individuals, assets held jointly with a spouse, but no one else can be used, in excess of $2.1 million, or a natural person who is an officer or director of the investment advisor or one of their IARs, who has been employed in the industry for at least 12 months. So please notice that the inconsistency in the rule, it is at least $1 million in AUM with the advisor or net worth in excess of $2.1 million. Why couldn't they both be at least in excess of? Makes the test tougher, doesn't it? The test may want you to know that a fee based on the average amount of money under management over a particular period is not considered to be a performance fee. There is one significant difference between the rules for state-registered IAs and federal-covered IAs. In order for a state-registered IA to enter into, extend, or renew an investment advisory contract that provides for compensation to the investment advisor on the basis of a share of capital gains upon or capital appreciation of the funds of the client, the investment advisor must disclose the following in writing to the client: that the fee arrangement may create an incentive for the investment advisor to make investments that are riskier or more speculative than would be the case in the absence of a performance fee. Where relevant, that the investment advisor may receive increased compensation with regard to unrealized appreciation as well as realized capital gains in the client's account. The periods that will be used to measure investment performance throughout the contract and their significance in the computation of the fee. The nature of any index that will be used as a comparative measure of investment and performance, the significance of the index, and the reason the investment advisor believes that the index is appropriate. None of these disclosures apply to federal covered advisors, although from a practical standpoint, though it's not on the exam, most of these are made to clients. The most common type of performance fee is known as the fulcrum fee. In this case, the fee is averaged over a specific period, at least 12 months, with an increase or decrease in the proportion to the investment performance in the relation to the performance of a specified securities index. For example, the S&P 500 is a very popular example. For example, for each 5% that the client's account outperforms the specified index, the advisor would receive an increase to the fee of 10 basis points, or 0.10%. Of course, negative performance would have the same results. Next time we come back, we'll take a look at other types of fees, starting with the cash referral fee. Actually, let's finish it up because we're here. So, the test topic alert. There are 2 additional points related to performance-based compensation that you must know. Firstly, the advisor must use net performance. That is, consider both gains and losses. Secondly, with so many other rules, the administrator has the power to authorize this type of fee, even when the client doesn't meet the financial requirements. Cash referral fees. No discussion of compensation will be complete without mentioning payment for referrals. The SEC has not prohibited payment of cash referral fees by investment advisors to persons who solicit business for them. The Investment Advisors Act of 1940 permits payment of cash referral fees to solicitors, providing 4 conditions are met. The first 3 conditions apply to all cash referral fee payments. So what this means, ladies and gentlemen, for example, a real estate agent cannot pay a referral fee to a non-licensed individual. However, an investment advisor or insurance broker doesn't have that restriction. So the first condition requires that the investment advisor be registered under the Advisors Act. Thus, the rule prohibits cash referral fee payments to a solicitor by an investment advisor required to be registered, but who is not registered. The second condition prohibits payments of cash referral fees to a solicitor who is subject to a statutory disqualification, e.g. a solicitor who is subject to an SEC order or convicted of certain crimes within a 10-year period. The third condition requires cash referral fees to be paid pursuant to a written agreement to which the investment advisor is a party. Even if the first 3 conditions are satisfied, cash referral fee payments are prohibited unless they are made in one of 3 circumstances. In the first circumstance, payments are for the provision of impersonal advisory services. The second circumstance is where the advisor pays a referral fee to a person affiliated with the advisor, e.g. a partner, officer, director, or employee of the advisor, and this likely is the only case where the individual will be registered as an IAR of the IA. The third circumstance, and generally the most tested, in which cash referral fees may be paid, involves third-party solicitors who are not persons affiliated with the advisor. Where the cash referral fees are paid to a third-party solicitor who are not affiliated with the advisor, the following disclosures must be made. Unless for impersonal advisory services, the fact that it is a third party must be disclosed. This is usually accompanied by requiring that a separate solicitor brochure be delivered along with the advisor's brochure. Any script or sales approach used by the third party is the responsibility of the advisor. According to the SEC staff, failure to adequately inform clients of a referral fee arrangement may be a violation. The amount of the remuneration and the basis on which it is paid must be disclosed, together with the fact that the finder is being compensated specifically for referring clients to the advisor. Finally, the SEC requires investment advisors to keep copies of the following material pertaining to solicitors and referrals: evidence of a written agreement to which the advisor is a party related to the payment of such fee, a signed dated acknowledgement of receipt from the client evidencing the client's receipt of the investment advisor's disclosure statement, and a written disclosure statement of the solicitor, a copy of the solicitor's written disclosure statement, copies of the investment advisor's disclosure documents delivered to the solicited client by the solicitor. The rules are much simpler for state-registered advisors. Under the Uniform Securities Act, in almost every case, anyone who solicits on behalf of an investment advisor must be registered as an IAR. I'm not going to go over the questions here because there's a few of them, and we're not going to go into the Safe Harbor Act either. Ladies and gentlemen, that's going to be it for today. Make sure you hit that like, drop a comment, subscribe, and hit that notification bell so you're made aware every time I release new content. And as always, share, share, share. Lastly, to contribute to channel growth, to purchase life insurance directly up to $1 million with an instant decision and no medical exam, or to schedule a one-on-one appointment with a licensed financial professional, the links are in the description. With that being said, wipe ass, work in progress every day, and see success. And remember, when people challenge you, they don't challenge you to challenge you, but they challenge you to challenge you. Accept the challenge. Salute, salute, salute. Hey folks, this last video was sponsored by my company, where we help people like you to reach their financial goals. We do this through a simple conversation where we help to identify and then protect your lifestyle, and then we implement a plan. The process starts at about an hour. So, if you want more information, or you want to schedule a consult, contact me via the information in the description box, and let's talk and see if we're actually a great fit for each other. And remember, ladies and gentlemen, when people challenge you, they don't challenge you to challenge you, but they challenge you to challenge you. Accept the challenge. Thank you, and enjoy life.